Great. Thank you, everyone, for joining us for another episode of GreenSky's podcast. This is a mini series where we cover topics around term sheet. I have three guests with legal and investment background from the perspective of an investor, an entrepreneur, and an investor, entrepreneur, and legal professional who've been doing this for many years. Maybe I can pass it on to our guests to introduce themselves. So we'll start with Mark.
Yeah, hi, thanks. Hopefully, everybody remembers me from the previous two episodes, and everybody's listening to this one as well. Marc Shewchun, partner at Fasken in the emerging tech practice here in the Toronto office of Fasken, a large Canadian law firm, or one of the largest Canadian law firms with a full service practice. My practice is very much working with founders at early stages, especially on these types of issues that we're talking about. I have a long history as a lawyer, but have also worked in a couple startups in a very early stage startup with like 6 people, a mid-stage startup with about 100 people, and then a later stage public company, which was no longer a startup. So got quite a broad background. I really like working with founders.
Awesome. And James?
My name is James Brink. I'm a partner at Ormston List Frawley. I've been with the firm for about 15 years since it was newly formed by one of our other guests, Mr. List, along with the other 2 partners at the time. From the outset, the firm was very entrepreneurial. I was really focused on, as a corporate and securities boutique, it was focused on incubating new companies. So as both a junior lawyer and now as a partner, I got an inside look at, how these companies are formed and grow over time. We work with investors, early stage companies, more mature companies, all the way from, formation to financings. So both on the investment and the entrepreneur side, as well as, company exits. And we've got a securities group as well that can, assist with, any companies that are looking to go public or kind of stay in compliance when they are public. So
Awesome. And Mike?
Mike List. I'm a founder and managing partner at GreenSky Ventures, Canadian-based series of venture funds. A former partner at Ormston List Frawley. I've been replaced by far more competent younger lawyers like James, but had a 10 or 15 year run as kind of a corporate lawyer at the same time, and also an entrepreneur. I've had multiple exits. Started 15 or so companies. So I've sat at most of the seats at the table, and I'm very much looking forward to chatting with my colleagues here about control provision.
Great. So we've, over the past 2 episodes, we talked about term sheet, the fact that it's the blueprint that governs the relationship between the investors and these startups. We talked about the economics provisions and as well as shareholder rights. In this episode, we want to dive deeper into control provisions. And Mike, maybe we can start with you, kick it off. Why control rights exist?
Well, I don't know if I have time for that, but I'll go at a very high level. So control rights are probably somewhat of a misnomer. What they are is a handful of rights given to typically a group of investors to allow them control over a select group of decisions. Typically, the decisions over which they have negative control means they can't force the company to do a positive thing, but they can stop the company from doing that thing. Tend to be decisions where that investor's capital would be put at significant risk were that decision to be made. So some examples of decisions over which a control right is typically available would be the wind up of a company, liquidation, borrowing large sums of money, non-arm's length transactions, so self-dealing when an entrepreneur has to set their comp, the sale of all of the assets of the company or the intellectual property of the company. It's things that really, were they to happen, would have a fundamental impact and potentially an outsized impact, negative impact on the investor class of shares. And so what an investor most often, I think always often always would do is to ask that a series of these rights be put in place to provide them that level of protection. And it's worth noting that as a seed and Series A round investor, while we enjoy these rights after we've invested for 2 or 3 years, we would also think it would be quite typical, and it is typical, for us to lose those control rights to a subsequent larger growth investor at some point in the future. And so again, the real idea is it's always the last money in, first money out, and most protected money. And that's kind of the principle that often informs these control rights.
And where are the board members when it comes to these negative control rights? So would the power be given to pref shareholders? How does that work?
I mean, I'm going to let my colleagues. The question really is, what is unanimous shareholders agreement, and it revolves around the ability to remove some of the rights you would normally give to the board and hand them off back to shareholders. But I'll let maybe Marc handle that one.
Yeah, I mean, in terms of the way it's architected, I would. It gets technical, but
we're not afraid of that.
Yeah, I'm not.
We'll happily answer, but you may lose all your viewers within 2 minutes.
I mean, it's probably maybe worth stepping back for a second. What is the board of directors? What does the board do, right? The board has overall responsibility for the running of the company. They're appointed by the shareholders. They have a fiduciary duty to act in the best interest of the company. And so they start obviously by what is our strategic plan? Who should we hire? Who's going to be CEO? How are we going to delegate functions down into the organization? Obviously, one of the big things is capital raising, financing the business. Those are all board level decisions. So what you end up with in a venture deal is what are the constraints if you think of the board as being the people basically that do everything and have essentially all of the control over the operations of the business and the capital raising of the company, what things does the board need to go get shareholder approval for or investor approval for that they otherwise wouldn't need to get that approval if they didn't agree in a shareholder agreement or in the articles of the company? That's kind of the architecture. So it's really shifting some of the control that the board has to the investors. I mean, it's a little more complicated than that. Not only that, but often you'll see not just shifting control to the investors, but shifting control amongst the board. So investor directors will have specific matters that they have to get their vote on certain actions. So it may not be just a pure majority vote of the board.
And Marc, with respect to, let's say, the number of folks that will sit on a board, or what is customary at a seed round with regards to the provisions that are talking about the board, what do you usually see?
At a seed level, from founder perspective, I always say less is more. So I would never want to see, or I would say never, but I would like to see a 3-person board at a seed stage. And this will be an interesting conversation with Mike and James, because I think this has evolved. But, in the earlier days of my practice, I would have always said to founders, it should be 2 seats for the founders and 1 seat for the investor. And those 2 seats, they're your founders, they're your seats. You own those seats. And it shouldn't be tied to your service or anything. And it shouldn't be, you basically do whatever you want with those 2 seats. It's like property in your house. And then you'll let the investor come in and take a chair at the table. This is going to get way too technical for this conversation, but it's amazing how that's transformed and how there's a lot more nuance now in the way board structures are set up. And I find it's probably one of the most negotiated parts of the deal. Next.
I was going to say, Marc, it took 2.5 episodes, but we finally have an issue that we can take it on where we're not in agreement. So I would say that the idea, and we have been through, and I'm sure, Marc, you've been through this as well, founders where for whatever reason it doesn't work out and you need to move them along, or they get moved along, not just by an investor, but by what's happening in the background. All sorts of things can happen over the 8-year life that we typically are invested in a company. My view would be I would agree with you to the extent that I view those two seats in your hypothetical as being owned not by the founders but by the company, by the common class. And so what I would I guess argue is that they're not the property, so to speak, of those two hypothetical founders, that they're in fact the property of those founders plus any of the friends and family co-common shareholders, and that common class as a group is really because otherwise they have absolutely no voice. But that common class as a majority votes on who those shareholders should be. I would say that I'm generally in agreement that a small board at a seed and Series A stage is better. As companies achieve more success, there are obviously different reasons why you might augment the board a bit and it might grow slightly. The one thing that I would add is that we often request that there's a fourth board member. So my view is that I've never been in a situation where like you need to, and I'd even happily give one of the commons a casting vote, so a tiebreaker if it came to that. But I don't view the board as a body that makes decisions by majority. It typically, 99.9% of the time, it acts by consensus. The fourth board member that we often ask for the company to find within 6 months of our investment is a independent that both GreenSky, the lead investor, GreenSky in our case, and the commons agree to, who brings a specific background. So they have industry experience in the industry in which the company is working. And our view is that level of input at the board, particularly for younger founders, is critical. It is incredibly important from a business perspective. That person often ends up acting as a mentor. They do a bunch of things. They make introductions to clients. But having that type of person on the board, I think, is well worth kind of the potential tie situation that you create by having a board of four.
And James, so we usually at GreenSky tend to go in as board observers with the right to kind of convert that to board seat. Can you tell us what is the difference here?
So a board seat is a voting position, and the person who takes that board seat becomes a director of the company. They now have fiduciary obligations to the company to act in the company's best interests. An observer has a seat at the table, but not a vote. Now, I would still say that as an observer, typically the people that you bring in as observers are people with a lot of experience. So even though they don't have a vote at the table, they do have a voice, and sometimes outside influence as that voice at the table, even though they can't typically vote. So I have had clients that are reticent about appointing observers for that very reason, just because they don't want to be unduly influenced by having too many observers at the table. But yeah, really the difference comes down to, do you have a vote or do you have a voice? And the flip side of that, of course, is that once you do have that vote and you do have that fiduciary obligation, there is some liability that is attached to that. Now, in GreenSky's case, there are some particular considerations around first taking an observer seat and then potentially becoming a board director, just in terms of its reporting obligations. If it takes the board seat right away, then there can frequently be an obligation to report new outside business activities in the context of, because GreenSky is a regulated entity. So there's some advantages to GreenSky in taking that observer seat. They still have a voice, but then later on sometimes if it becomes a more contentious issue, then GreenSky will kind of elect to appoint its board seat, where it then gets to exercise the vote. But a lot of times it's content to kind of join the board in that observer position. But you will find, more broadly on venture deals, that board seat will get occupied right away by the investor. So.
And I mean, I have my personal experience talking to entrepreneurs where they're almost they just maybe filled up a pre-seed round and they have a 7-person board kind of, which is often very complex and convoluted to manage and go through. I don't know if there's a solution for a disease like that or
Pruning,
not,
extensive pruning.
but
Because you might.
but I've definitely seen that as well. And I'm curious to hear your opinion. What are the challenges with like having a board that large at that early in the life of a company?
Sorry,
Was that addressed to me or to Mark?
Mark, you can take that because you work with a lot of startups too.
And my internet just cut out for 10 seconds. Can you repeat the question?
Yeah, like what are the challenges for a startup company that has a board that is, let's say, a 7-person board at
Right.
very early stage in their life cycle?
I always think that the quality of the conversation is inversely proportional to the number of people in the room. So if you want a high functioning board, 7 people you're getting to the level where I just can't see you're going to get a lot of great stuff done in that meeting.
I wholeheartedly concur. I've never heard it quite said that way, but it's the best description is that the value that you get, and think of it literally as this is an asset that if you manage it properly can be incredibly valuable to particularly younger entrepreneurs. The larger a board is, likely the inversely less the less valuable that group will be to you. And so I agree 100%. It's partly why I also think going and finding a domain subject matter expert, even as an independent, to put on is very useful. But I think 7 people, it's like 7 people trying to make dinner. Like it just doesn't work. It just is. It's too many cooks in the kitchen.
And this may not be really a legal question, more of a negotiation tactical point. But I've seen, let's say, in a $4 million round, there's a lead investor coming in with like $2 million, filling up 50% of the round. They obviously would request to have a board seat or, let's say, an observer seat with the right to convert. Then there might be other parties that are coming in with smaller check sizes, like let's say $1 million or $500,000. And then all of a sudden they also ask for board seats or even 2 board seats. What should be an entrepreneur's response to that? Mike, I can start with you because you've been an entrepreneur and you've worked with entrepreneurs. What do you think about that?
The response should be no. Tongue in cheek, the only time I would bend from that is in the event that it wasn't a typical group of investors, so not a normal syndicate of, let's say, a bunch of institutional VCs, but in the event you had, let's say, a strategic. So you were doing GreenSky led a round recently into one of our companies, and we had a large global VC co-invest with us, and they'd asked for not an outsized number, just they'd asked for a board seat. And we acquiesced because, again, the value you get from having that person at the table is far outstrips the voting concerns, who gets what vote. It's a way better thing to have that person, in my opinion, in the room. So again, I would say if it's just a large group of institutional investors that form a syndicate, then I wouldn't bend on that basis. But if you have a strategic reason to do it, then that's a different story.
Yeah, I mean, if it's just a case of monitoring the investor's investment, there are better ways to do that. That may involve an observer seat. That could involve information rights. Regular reporting, without necessarily giving every investor that comes to the table a vote and seat at the table. And yeah, I mean, I guess that would really be the explanation to the investor is just, when it comes to decision making, we need to, keep things narrowly focused. We've got mechanisms built into the shareholders agreement already when it comes to key decision making. There's say a vote of the majority of the investors on certain fundamental decisions. That's where you exercise your voice, and we'll keep you in the loop as far as information rights are concerned. But in terms of the board composition, we want to stay narrowly focused on people that are either involved in the company, i.e. the founders or representatives of the common shareholders, a representative of the investors, and maybe somebody with domain matter expertise. But I mean, everybody that's contributed to this conversation so far is correct. Like too many cooks spoil the broth.
That was, by the way, a real story.
Yeah.
Awesome. But that was a great segue to information rights. And Mark, maybe I'll turn to you. Like, what are the information rights? What are common? common things in term sheets regarding the information rights?
Yeah, thankfully there are some standard information rights referring back to the model documents, CVCA model documents. There is a standard set of rights. It includes financial disclosure, so annual financials, could be quarterly financials, a budget, business plan. There is often, some general rights to talk to management, come visit your offices should people want to come visit your office. But if you're a fully remote company, that might be awkward. So there's a standard set of rights. I would say usually when I talk to founders, it's probably one of the areas too where founders don't read it carefully enough, and then after the deal is done, they go, "What? I said I would give quarterly financials within 30 days of the quarter end. I can't do that." Or somebody slips in audited annuals, and they're like, "Audited? I can't. I don't have. I can't afford to do audited financials." So it's important to read it and work with counsel and to make sure that it's right sized for the stage and level of your business. And I make sure I point out to founders, please read this very carefully and let's talk about it. And are you going to be able to meet these obligations? And I think it is very helpful too for founders to think of this as like stakeholder communication. I'm going to do regular communications with my stakeholders. I want it to be uniform, so try not to give too many special information rights and side letters. Like, think about what is going to be the package that I'm going to get out to my stakeholders on an annual and a quarterly basis, and make sure everybody's kind of okay with the one size approach to that as much as possible.
And Mike, from the perspective of an investor, like we obviously ask entrepreneurs on a quarterly basis to give us information about where the company is, etc. Why is that important for us?
For all sorts of reasons. Before I get to that, I would echo Marc's comments and kind of double down and say, like, a warning sign for me when I was raising, and we've never included it in any of our term sheets, but certainly at the seed and Series A, even into the kind of the growth stage, Series B and C and so on, a request for audited financials is absurd. It doesn't make any sense. It is a spend that is completely unnecessary. It's basically bleeding the company of $15,000 to $20,000 per annum for very little value, in my opinion. Again, in the case of a public company or institutions where there is a value, that's a totally different thing. But for a small innovation startup, having the requirement to have audited financials doesn't make any sense. So I would take that as a bit of a warning sign, even just to see that in the term sheet. The reason why we want information rights as partners is because and I'll speak to GreenSky's approach to how we interact with our companies. I don't invest in a company because I want to come in and take over. I'm investing typically in a team of people I believe can execute. Where we provide the most value is at inflection points. So we've built, in the case of GreenSky, a team where I have a significant amount of deal experience. I happen to be an ex-lawyer. So I can go in and I don't charge for it, but I go in and work with our entrepreneurs if they get, let's say, a master services agreement, or they have some proposal for a large license deal, or they get approached for an exit. I often am, we've had 5 exits across our portfolio. In 4 of those cases, I've been literally a co-lead, and I think it's been a very good relationship with each of the entrepreneurs with whom I've worked, but to help kind of, optimize that outcome. My partner Valdis is a very experienced technology executive, has spent I think almost 40 years now in the Canadian ecosystem. Was the chief information officer at BlackBerry from 2005. You will not meet a guy who's more experienced than Valdis when it comes to scaling technology. He will step in. He's not just useful for us to kind of do the diligence on these deals, but once we've invested, we'll step in and mentor a lot of the CTOs and CIOs as they get to the point where they scale. Again, I'm giving you kind of these individual examples of how our team members interact with these companies, but if we don't know what's going on, if we don't get those information rights, then we can't actually step in in a timely manner, again, at these inflection points to help when it's needed. The other reason, and it's more simple and boring, is we as institutional investors have our own investors who want to know what the hell's going on with the portfolio, and we need to report back to them. And if the companies won't tell us, then we don't have anything to report, and we tend to get our investors take quite a dim view, and we can't tell them how the portfolio is doing.
Great. So on the topic of control rights, I want to again do a round of 1 minute. What was the biggest mistakes that you've seen in the startup make, or what is the red flag that you want the startups to avoid? I can start with James if you want to kick it off. 1 minute. What is one of the biggest mistakes you've seen a startup make regarding that in terms of
So I don't know if this is a mistake so much as a general attitude that entrepreneurs, when particularly if they haven't done these sorts of deals before, they look at the list of negative control provisions that are like, oh my God, like I don't have any control over my company anymore. And yes, it's a long list of things, but investors are not interested in running your company for you. They're there to help you run your company, and they want to be part of those major inflection points. And if you look at if you kind of go through the list of items that comprise negative control rights, sort of one by one, like these are all things where you should be picking up the phone and calling your lawyer if you want to engage in one of these transactions. And on those transactions is when investors want to be a part of it. They want to be part of the decision making. They want to know about it. They want to be part of the decision making process. But this is not day-to-day operational stuff for the most part. Even when it comes to hiring decisions, I mean, we're not talking about investors, monitoring, your day-to-day hires. They're more interested in, your C-suite, the people that require board approval in order to hire. And things like, non-arm's length transactions, they certainly don't want to see any self-dealing types of transactions. They don't want to see you go out and raise money without them, getting some notice of it, especially if they have participation rights. So I think that's most often the aspect of the negative control provisions that I really have to kind of walk entrepreneurs through and say, this is not day-to-day stuff. This is not operational stuff. This is stuff that has a material impact on the investment. It looks like a long list, but you're not often going to have to pick up the phone, call your investor, and say, do you consent to this transaction? Because they're material events. It's not everyday signing of a contract or a new hire. So,
and Mark, what are some of the things that you've seen, or what are some things that comes to your mind with regards to red flags, mistakes?
I think, philosophically, I understand why they're there and agree that investors should have them. The mistakes or the things that I find annoying about control rights, or maybe sometimes negotiating control rights, is very much in the weeds, which is like there's, one dimension is making sure they're actually like clear what they mean, so that when you're going to read them, you actually know, is this a decision that requires an approval from the investor or not. The one that I can't stand is the do anything outside the ordinary course of business. When I see that, I just lose my mind, because I'm like, every startup, every day I'm doing something outside the ordinary course of business. So sometimes investors will ask for, I think, control rates that are just way too impractical versus very clear lines. Like if you want to raise more than this much debt, or you want to go, hire a new CEO. Okay, those are clear. I get my head wrapped around that. We know what that is. It's easy to understand. Then to me, the next layer is like, whose approval? Like, the less that I have to go to my shareholders my investors as shareholders, versus I can get the board nominee to approve. So I'll try and push as much of that to the board level, right? So Mike's the ambassador for the preferred shareholders. Mike, are you okay with this? There's a big difference than getting Mike. Then I got to go and talk to maybe 6, who knows how many investors in a company I have to talk to get preferred majority approval. That's really annoying. I'd like to reserve that to the smallest number of decisions as possible, that I have to go to that group of people.
And Mike, I guess I'll change the question for you a bit. What are examples that you've seen where you were relieved that you have the control rights there, or you were unhappy that you don't have a specific control rights there?
I'm gonna equivocate a little on that, just because at the risk of telling tales at a school, like we've had a bunch of really interesting things happen. We used control rights in one instance to achieve a transaction that was incredibly beneficial for 98% of the people involved, but I don't want to use specific names or examples just because a lot of our transaction history is public knowledge. What I would say in a broader way is that where I most often find that I trip over this in this area an issue, and it could be all sorts of things. The one that comes up all the time, and Mark and James, you must see this, is the option pool. Like entrepreneurs come and they say, well, I don't understand why I'd have to get permission. This is my company. And what really I would say as a kind of an overall piece of advice is the times where I experience friction, which we do try to manage and we work our way through, but where you experience initial friction is when the entrepreneur has gone back and talked to people that know enough to be dangerous, but don't know enough to be experts. So it's a founder who's raised friends and family, who's got one other founder or a family member, somebody who's done a tiny bit of VC investing. And the advice they get back after they've marked up the term sheet, you can tell when a non-lawyer has been through a term sheet and doesn't have a sense of what market is and what the standard terms look like. I would again say, and at the risk of kind of overly promoting my friends on the podcast here, is go and find a competent lawyer and find somebody who's been through and who's done a bunch of these transactions. While it may seem like you don't want to throw money away and you don't want to spend money on lawyers and accountants, etc., it is incredibly important to have sophisticated expert advice from the outset when you get a term sheet. So I find the biggest mistake that entrepreneurs often make is try to negotiate the first 2/3 of a term sheet on their own, thinking that I'm going to save a bunch of legal fees. I'm not going to engage a lawyer in the background. I'll get it from a business perspective to a point where this will work. And I think you can tell just in terms of even some of the issues we've touched on today, how deeply complex this can be. Doing this without an expert is a very unwise thing to do. So I guess my overall piece of advice would be, call James or Mark if you don't have a lawyer already, and find somebody that can help you, because you'll be way better off in the long run.
Great, thank you, Mark, thank you, James, thank you, Mike. I think that's it for the episode on control rights. Thank you so much for being with us and spending your time with GreenSky's podcast. If you have more questions, reach out to Mark, James, or Mike or myself.
Thank you.
Thanks everyone.
Thank you.
Bye.